Yep.
My Lords, I was showing you before lunch the two different strands of reasoning in the Court of Appeal's judgments, what I've called the real choice reasoning and the true alternative reasoning, and I now wish to turn to criticisms of the true alternative reasoning, and your Lordship has seen what that consists of, some supposed requirement of difference in nature or kind of the courses of action taken and avoided, or some difference in the expenditure inherent in the courses of action taken and avoided. And, my Lords, we say that in this case the Court of Appeal, as indeed my learned friend, have just failed to resist the temptation to gloss unnecessarily very clear language in Rule F itself, which your Lordships will find at page 442 of the bundle, and it is useful to have those words in front of you. This is a rule, as I have said in our case, with international currency, that should in our submission be construed on broad principles of general acceptation. Your Lordships will know where that language comes from.
Yes.
That is to say, my Lords, in accordance with its simple language. An extra expense incurred in place of another expense which would have been allowable in general average. There is no requirement there for that the extra expense should be the product of a course of action different in kind or nature from the course of action that would have led to the other expense. Frankly, my Lords, there is no reference to courses of action at all. Yep. And there is no suggestion in the rule that the extra expense must be different in kind from the avoided expense, whatever that might mean, as to which see our case at paragraph 71.4, page 100 of the bundle. That is another gloss. None of the textbooks have ever suggested such requirements. The words of the rule are straightforward enough. The requirement is simply that the extra expense should have been incurred in place of another allowable or some other allowable expense. And my Lords, if you're looking for our core submission, it is to be found in paragraph 49 of our case, where we say that it is no distortion of language to say that the negotiation period expenses were incurred in place of agreeing the first demanded ransom. There was an alternative to negotiating the amount of the ransom, and that was to agree to and pay what was demanded at the outset. And subject to issue 2, that is sufficient to satisfy the rule. Rule F was engaged.
Right.
Now, my Lord, my learned friend does not in fact seek to support these superadded requirements found by the Court of Appeal, and your Lordships will see that in his case at paragraph 95. That is page 157 of the bundle, where he says, many of the examples of substituted expenses involve expenses being incurred in pursuing an alternative course which is different in kind to those expenses that would have been allowable and have been avoided, whilst the respondents do not go so far as to contend that it is a requirement for Rule F to be engaged that the expenses incurred must be different in kind or nature from the hypothetical expenses. A court should be particularly cautious in deciding that the two courses of action, which involve the same kinds of courses and the same kind of expenditure, fall within
we have that. Thank you.
Rule F.
Yep.
That's paragraph 95 of my friend's case. Plainly, he is not supporting as intrinsic in Rule F the true alternative line of reasoning. And we say it's therefore not very surprising that he has had to have resort in his case to other grounds of seeking to uphold the decision on issue 1. And your Lordship knows our points on that. My Lords, just occurred to me, or occurred to my junior, on Friday last week we sent a list of points objected to your Lordships, and we just wondered whether that had reached you. It's a short document, 3 pages. It has. Well, I'm glad it has. I wasn't quite clear that it had.
It certainly reached me.
Yes, well, I'm
grateful.
grateful.
I have a copy with me.
I'm in the same position. It reached me too, but I didn't.
We can supply additional copies. My junior is going to jump.
How would I did with it? I'm afraid I don't know.
Yes. Well, it wouldn't have been obvious to your lordships why we were objecting or what the grounds of the objection
Well, since at the stage when I received it, I hadn't read your printed case, I confess that it meant very little to me.
My lord. I hope it makes just a little more sense now.
Anyway, the answer is yes, we all got it, and some of us have it, yes?
Yes. My lord, since I've interrupted my reasoning, my submissions, I should also deal with another point that was raised before lunch, and that is how we should deal with issue 2. Now, both my learned friend and I are entirely in your lordship's hands, but we would point out that we think issue 2 can be dealt with in submission really quite quickly. It's probably about 35, 40 minutes for each of us. And we wonder whether it wouldn't be more efficient just for me to roll on.
Okay.
Yes?
Fine, yep.
Rather than just bifurcating an hour's on.
Said yes. Yep.
Yeah. Right. My learned friend says there has to be caution about accepting that 2 courses of action involving the same kind of course and expenditure satisfy or engage Rule F. But, my lord, that's a little mysterious. It's either intrinsic in the rule or it isn't intrinsic in the rule. Either Rule F is engaged when the courses of expenditure are similar, or it isn't. And this suggestion of caution, how is it to be exercised? What matters are to be guarded against in relation to this caution? What principles are to be applied in governing the exercise of caution in relation to Rule F? My learned friend doesn't make any suggestions, and I look forward to hearing him on the point. My lords, having given up on the Court of Appeal's ground of decision on true alternative in his case, can I ask your lordships to turn to what he does say now on this? It's in his case at paragraphs 114 and 115, page 163 of the bundle. Submissions on issue 1.
Yep.
Paragraph 114, the clear view of the commentators shared by the judge in the Court of Appeal is that for Rule F to apply, there must be at least 2 alternative courses of action open to the ship owner. We prefer the language course of expense, but subject to that point, we agree. However, then he goes on at 115, the ship owner must make a choice between the 2 courses of action with the intention of avoiding or saving expenses that would be allowable in general average if the alternative course had been taken. Now, my lords, this is an entirely new argument. Not made before, not part of
Okay, we got that, yep.
Yep. It also finds no justification at all in the wording of Rule F. You can see what the rule says, some extra expense incurred in place of allowable expense. There is no reference to motive or intentionality.
So in place of is a question of fact, not a question of intention.
My lord, that's right.
Understood.
And if intention or motive had formed any part, take a look at Rule A, which is explicit in requiring that the relevant extraordinary expenditure in that case should have been incurred intentionally as well as reasonably.
You understand?
Yeah.
Thank you. Yep.
My lord, the requirement is also wrong in principle, and I'll take an example. Suppose a ship breaks down short of her destination and faces a long delay if she's to carry out permanent repairs at the nearest ill-equipped port of refuge. It may be cheap to carry out there in terms of allowable expense, but it will cause substantial delay to the cargo and prejudice the owner's commercial relationships with his shippers. So the owner decides to transship the cargo instead, or have his vessel towed to destination. These are both Rule F situations. And let us suppose that he does so at greater expense than the allowable expenses that would be incurred in carrying out the permanent repairs at the port of refuge. So he is adding to the expense. Now, plainly his extra expense, we say, in completing the voyage, should be allowed under Rule F in general average, but as the rule says, up to the limit of the saving in general average, an allowable expense that would have been incurred at the port of refuge. That is what Rule F says. And it matters not at all whether his intention in taking that course was to reduce the general average bill or to maintain his commercial relationship with cargo interests, or that he had some other motive or purpose. It's a convenient way of testing what my learned friend says. If you act out of a desire to protect your commercial relationship with your shippers and not to reduce the general average bill, why should you lose your rights in general average? We say that the shipowner should be allowed his extra expense of towage to destination or transshipment of the goods to destination, regardless of what his motive or intent was. Now, my lords, the example I have given you is a real-world example that arises from time to time in the case of container transport. A container line, a container vessel comes to grief short of destination, and the line will, in the case of breakdown, routinely forward containers to destination simply to fulfill the client's expectations, the shipper's expectations or the receiver's expectations that the containers will be delivered in accordance with the timetable of the line. And that happens routinely without any regard whatsoever to the allowable expenses that might be avoided at the port of refuge if, for example, the containers were all offloaded and kept on the quayside while the vessel were repaired and finally reloaded and sent on their way in the original bottom. My lord,
how narrowly you read the words with the intention of avoiding saving expense. In the example you gave,
yes,
there is still an intention of avoiding and saving that expense. Admittedly, there's an ulterior motive because although cheaper, it would damage commercial relations, but there's still the intention of not incurring that expense, but incurring a greater one with a view to avoiding the other expense and all the collateral damage it would involve.
I see your lordship's point, but let me put it this way. From a container line's point of view, it may give not the smallest consideration to what the allowable expense at the port of refuge would be. It is motivated, usually by commercial considerations, to get the containers to destination in accordance with the timetable, to maintain its commercial reputation. We say that intent is misleading in this rule. It's not there, and it shouldn't be forfeit. That is to say, the ability to claim the substituted expenses up to the relevant limit should not be forfeit simply because there was another intention or no relevant intention, such as my learned friend describes it. Intention also, my lord, comes difficult in the case that I put to your lordships before lunch of a substituted expense that is incurred by cargo. I put to you the case of the inhibitor, if there was an additional requirement to buy additional inhibitor. We, for our part, do not see in this case that that is not extra expense incurred by the cargo interests in this case, on the hypothesis put, in place of an immediate ransom of the vessel and the expenses that go with that. We say that falls fully within Rule F, were that to have been an extra expense incurred, which in fact it wasn't in this case.
Well, it wasn't in this case because it was expended after the release.
No, it's not that, my lord. In fact, it was never required. They never actually injected the additional inhibitor.
Well, does that matter?
No.
I mean, supposing they purchased it on the basis that it might be necessary, why?
And couldn't sell it back.
Yeah.
Yeah. My lord, if a claim had been put in in this case, by cargo interests for the additional inhibitor on the basis they couldn't sell it back, then why should they not get that expense under Rule F? But with what intention have they incurred that expense?
It might be said that it was actually an alternative to the deterioration of the cargo, rather than a means of allowing the negotiation, just looking at it objectively. What is the alternative to buying the inhibitor? On the face of it, the alternative to buying the inhibitor is suffering cargo damage, which, for the reasons that you submitted before short adjournment, might not be recoverable in general average.
I hear, yes, that is an alternative, but looking at it from the point of view of the decision which we're concerned with, which is the immediate one, whether to negotiate the amount of the ransom or not, you can see, were cargo interests to be there at the point of decision, and the shipowner had said, we'll negotiate the amount of the ransom, the cargo interest might say, well, that's fine, but do appreciate that if we take this course, we may well have to incur additional expense in buying replacement inhibitor. And on that sort of hypothesis, we would say that the notional additional inhibitor expense would qualify under Rule F. But whose intention matters here? We say intention is misleading.
But I mean, the only reason it's bought is because of the risk of deterioration of the cargo. So,
yes.
It's nothing to do with the negotiation.
Oh, no, my lord. But
no, whereas you say that the
it's just incurred in place of paying the ransom.
The delay, by comparison, is part of the patience required to carry on the negotiation. I mean, in all of these cases, there must be a point at which the expenditure is too remote from the supposed alternative to be included. And so your examples are not necessarily comparable.
You're suggesting I might have just gone beyond the line of remoteness.
Well, it's certainly arguable.
Yes, I see that. Yes. Now, my lords, referring back to my friend's case for the basis of his submission, but as I emphasise, there's a new point. He makes the basis of this submission, or explains the basis of his submission, at paragraph 73 on page 151 of the bundle. This is the requirement of intentional motive. And he refers to, if you look at the bottom of that page, he refers to the Bigella, an owner taking the hypothetical alternative course.
Sorry, which page are you on?
I'm sorry, page 151 of the electronic
73,
version.
Paragraph 73. Okay.
Paragraph 73, and it comes in 6 subsections.
Yes, yes.
And we're looking here for something to support the requirement of intention. Now, my lords, the references to the Bigella do not support a requirement of intention. They speak in terms of choice, but no specific intention. There is the judgment of Justice of Appeal Shepherd in the British Columbia Court of Appeal in the Western Canada steamship case. I'm going to come back to that. There is then a reference to the supposed requirement of intentionality or voluntariness, which underpins all claims of general average. And if you follow the footnote, that is a reference back to paragraphs 37 and following. 37 and following is on page 141 of the bundle. And what one finds there, paragraph 37 and following, is reference to some cases and principles that arise in English common law and on the Marine Insurance Act and on Rule A. Now, my lords, English common law never knew substituted expenses. It has no concept of them, or at least none was sufficiently developed, and it allowed general average really only in Rule A circumstances for preservation, for the common safety of the adventure. And it's no surprise to find there that there is a requirement of intentionality. One finds it in Rule A as well. None of the authorities my friend refers to in paragraphs 37 to 47 of his case are anything to do with substituted expenses. Rule A states the requirement of a General Average Act, as indeed does in similar language section 66 of the Marine Insurance Act in English law. They are very similar indeed. But Rule F does not suppose a General Average Act. It supposes expenditure incurred in substitution for what might follow from a General Average Act. So this supposed requirement of intentionality and voluntariness is entirely confined to English law, which knows no concept of substituted expense, and Rule A cases, which are quite distinct from substituted expense. Intentionality is clearly an element in the incurring of extraordinary expenditure for the common safety under either the Marine Insurance Act or the common law case principles or Rule A. But it has no application to substituted expenses. And if that had been part of the thinking when introducing Rule F, it surely would have been specified. Now, if I go back to page 152 in my friend's case, this is where he is seeking to justify the requirement of intentionality.
This is paragraph 71 still.
73, my lord. 73.
Still. Yep, 73, yep.
And I'm back at page 152.
Yep.
There is a reference to the 12th edition of Lowndes. This is in subparagraph 4. Now, this is a passage in the 12th edition dealing with what is meant by, it says additional expense. It means, in our context, extra expense. And he says, or the author, the editors there say, an additional expense would appear to be an expense incurred in carrying out an operation in a non-standard manner, and for which no specific provision is made in the numbered rules of the York-Antwerp rules, but which is incurred with the primary rather than incidental object of avoiding or reducing some other expense which would properly be admissible in general average under the rules. Well now, my lords, this is to do with what is meant by an extra expense. The judge found that the negotiating period expenses were extra expenses. There was no challenge to that finding in the Court of Appeal. So, if this passage were right as a statement of the law, the learned judge has found that the extra expenses, the negotiating period expenses, were incurred with the primary object of avoiding or reducing some other expense which would probably be admissible in general average under the rules. So if there is some requirement of intentionality, it is satisfied by the finding that these were extra expenses. But my lord, intentionality was never an issue before the judge. It was not suggested as a requirement of Rule F. And this passage comes from the, may I say, slightly eccentric 12th edition of Lowndes. It's not repeated in any later edition of that work, and for good reason, because the suggestion that extra expense...
When was the 12th edition published?
1997.
Yes, thank you, my lord.
Has there been how many editions since?
There's been the 13th and the 14th since.
Two, thank you.
Two.
Shall we have a look at the comparative?
Shall we have a look at the do you want to have a look at the at this section?
Well, I'm looking at it. Where is the comparative sections in the later editions?
Oh. We don't have anything from the 13th edition. We have the 14th edition.
Yeah.
And if you go to...
Seems to have changed.
Forgive me, it's page 1081. Internal numbering is 189.
Volume.
This is additional... Authorities Volume 1-2, 1 sub 2.
Okay. 1081, yep. Tab 22, yep.
There is quite a long section on what is meant by this stage, the 1994...
Do either of you rely on anything in here?
My lord, I was not going to show you anything in here.
But fine.
What's it? Where do we find 188?
Sorry, 181. 181, my lord.
Yep. Okay, thank you.
108.
So we're not looking for something, we're looking for something that isn't there, okay?
Well,
Where would it be if it was there?
my lord,
That's a little bit teleological, don't worry.
the paragraph F20 and following.
But basically, that passage is not in there, and you say no equivalent passage is there.
We say that's an awful lot to read into the word extra.
No, I understand that. What I'm saying is, we look in vain for anything
Yes.
for the repetition of the passage in paragraph 73(4) of the respondent's case, or anything equivalent thereto in the 13th that we haven't got,
No.
and 14th that we do have.
It's fair to say the 13th and the 14th involve the same editors,
Yes.
and they are different from the editors of the 11th and
Okay,
12th
thank you.
editions.
But it's not so different, is it? The 11th says it's not a mere enhancement of an ordinary voyage expense which the carrier should bear as an obligation under the contract of affreightment, nor should it be one which a ship owner would incur as part of his regular repairing programme
Yes.
procedure. Well, that's obvious. But if you look at page MS 1082, again, it says here it's not necessary for the course to fall completely outside the contractual obligations. However, in the context of the rule, an additional expense must at least be something that goes beyond the ordinary voyage expenses
Yes.
that might have been contemplated when the common adventure began. They would normally include some element of contingency, and then it talks about such elements of earning freight may be enhanced by factors outside the shipowner's control, but this is a commercial risk that is taken as part of the earning freight. It must be something beyond the normal or standard means of repair, if you're talking repair. So, I mean, the idea is the same, isn't it? It's just
broadly the same, but I think
Yes.
what my learned friend liked in the 12th edition was the reference to the primary rather than incidental object of avoiding or
Yes, I
reducing
see.
some other expense,
Yes.
which would properly be admissible in general average under the rules. So, taken at face value, that appears to suggest that the word extra, or supplémentaire in French, carries with it a whole baggage of intention. And
Yes, you're on the
object.
intention.
Yeah.
I'm rather on the risk element
Yeah.
and the idea that these are running costs of the ship.
Yeah. Well, I may have to come back to that point, it appears. At the moment, I'm addressing my learned friend's points, which are if I fail, my lord, to address your point on running costs, maybe I should be reminded at some point.
possibly in a judgment.
Well, I hope a little before the judgment.
Well, perhaps your Leonard Junior will come in handy.
Maybe he'll kick me at the right moment. Now, my lord, we've said that the 12th edition is eccentric in places, as indeed was the 11th edition, and we find it therefore rather interesting that my learned friend prefers to rely on the 11th and 12th editions at many places in his case, in preference to the 13th and 14th editions.
Yep.
Another example of this is to be found in his case at paragraph 149. My lords, before I leave that,
Are you going to say something?
something about the Hudson
5 and 6,
references.
Hudson.
Yes, my lord, what we say again, here, these speak in terms of choice, but not of specific intention. Now, my lords, I was going to show you another section in the 11th edition, which my learned friend relies on. It's paragraph 149 of his judgment. I beg your pardon.
I think that's overrating it.
I'm certainly...
I'm sure he's very happy. He's very happy to agree that.
It's page 149 of, I beg your pardon,
What paragraph?
para 68.
Thank you.
This comes under a heading in his case, general approach to be taken to Rule F, rigorous examination required.
Yeah.
And if your lordship looks at this is another passage never again repeated in any edition of Lowndes.
I'm not quite sure where rigorous examination goes, anyway.
No.
I mean, either it's within or it isn't once you've analysed what it means and what the expenses are.
Yes.
Yep.
Well, my lord, this passage, which we can in fact look at in
Well, you say it's not in the 12.
it's not in any subsequent edition.
Okay, very well.
And
A
there are other
relaxed examination is permissible.
there are other eccentricities. There was another eccentricity in the 11th edition, which you can find just at the passage following this, where the suggestion was made that extra expense, which was the language, meant extraordinary expense. And it was suggested that extra was a contraction of the word extraordinary, which was really a helpless suggestion, given that the French word is supplémentaire rather than extraordinaire. Anyway, I'm just doing what I can in relation to the 11th and 12th editions. In our submission, some of the passages in those editions were not altogether reliable. I must return, however, to the dissenting judgment of Justice of Appeal Shepherd in the Western Canada steamship case, which my learned friend has relied upon in connection with a requirement of intention. Oh dear. And we deal with this case at paragraph 28 of our case, where we describe it in this way. These decisions, there were 3 decisions in Canada from first instance up to the Supreme Court. These decisions are principally concerned with questions of breach of duty by the carrier, questions of want of due diligence, causative due diligence under the Hague Rules, which if made out would have defeated any claim for general average. The issue in relation to Rule F was very limited, whether the total extra cost of flying an 8-ton propeller shaft from Wales to Singapore in a specially converted bomber, retired bomber. And we've given the figures in our case, 22,018 as compared with steamer freight of 246 odd pounds, could be allowed in substitution for the port of refuge expenses saved, namely $24 odd thousand. And it was held that they could. They were less than the port of refuge expenses allowable in general average that were saved. Now, that describes the result in the Supreme Court. In the Court of Appeal of British Columbia, which is the decision my learned friend relies upon, the majority of the court had found that the ship owners were in breach of their contract of carriage and claims for general average contribution were for that reason defeated. Justice of Appeal Shepherd did not, however, join in that conclusion. He was a dissenting member of the court, and he was therefore the only member of the court who dealt with the general average points. Now, in my learned friend's case, at paragraph 88, where he deals with this, there is an error. He suggests that the expense of carrying the new tail shaft by air was claimed in substitution for the cost of transporting it by sea. My lords, that's an error of analysis. It's the difference between the air freight and the sea freight costs that defined the extra expense. Now, the argument that appears to have been addressed to the Court of Appeal of British Columbia was whether that extra expense was incurred in place of the allowable expenses at the port of refuge, which the carriage by air had obviated. There were costs of crew while waiting for spare parts and the like, or whether they were incurred in place of some undefined other losses that would otherwise have been sustained through delay, and those would not have been allowable in general average because Rule C excludes from general average the consequences of general average acts attributable to delay. And, my lords, in that context, and I can show your lordship what the judge said, it's in Authorities Volume 1, at tab 15, page 890 of the electronic bundle. Oh, your lordships may have difficulty in following this in the... Page 87. It's page 87 of the internal. Of the printed volume.
Sorry, I haven't got the reference.
If your lordship is looking at the printed document, the page numbers are hard to make out at the bottom right. If your lordship is in tab 15 and turns to page 86 at the top left.
Right, thank you.
And then turn across to the next page, which is 87. Sorry, it's 87. And if you pick it up in the second paragraph, as to the second contention, the defendants say that the allowance was in error because the air freight was not incurred in place of allowable expense and hence not within Rule F. Rule C provides in part damage or loss sustained by the ship or cargo through delay on the voyage and indirect loss from the same cause, such demurrage and loss of market shall not be admitted as general average. The defendants contend that the expenditure for air freight was for the reason that the plaintiffs must assume the loss from the delay falling within Rule C, and the use of air freight was for the purpose of avoiding such loss and therefore was really incurred not in place of allowable expense as required by Rule F, but was incurred to prevent this loss which was not recoverable under Rule C. So that was the argument. And then the judge goes on. On the other hand, the plaintiff contends that the wages and maintenance of the masters, officers and crew are allowable under Rule 11, and that it was the natural result of the use of air freight that such allowable expense was not incurred. The question is, what was the plaintiff's motive? The use of air freight would prevent the incurring of expense allowable under Rule 11. That would be readily foreseen. Hence, there is evidence on which the learned trial judge could find for the plaintiff, and that finding, being one of fact, should not be interfered with. So, my lords, my learned friend is able to point to this dissenting judgment in the British Columbia Court of Appeal as possible persuasive authority in favour of some requirement of the shipowner's motive being to avoid allowable expense, simply being a consequence of the incurring of the substitute expense. My Lords, we do question how persuasive as an authority this is for an introduction of a requirement of intention into Rule F. Is the extra expense to be disallowed simply because the owner's private motive was also to avoid some other non-allowable loss? What about mixed motives? What if the motive was generally to reduce expense and loss without thinking too clearly about what expenses or losses would be incurred by shortening the time of the delivery of the relevant spare part? It's not clear from any of the reports what these non-allowable delay losses allegedly sought to be avoided were. They don't find any reference in any other part of the report. And frankly, they're not referred to anywhere that I can find. The particular argument apparently addressed in the British Columbia Court of Appeal didn't feature in the court below, didn't feature in the Supreme Court. There's no hint or reference to it. I can certainly find no trace of it ever having been addressed to the Supreme Court of Canada, where the only argument apparently addressed was whether air freight was an extra expense. And Justice Ritchie said, you'll find it in the next tab.
Isn't it clear what the allowable expenses under Rule 11 were? They were wages and a port of refuge.
Yes, indeed.
Yeah. Extra costs incurred through having to go into a port of refuge.
No, extra costs was the extra cost of carrying by air freight.
No, sorry, yes, but the ones which would have been allowable for the
avoided allowable expenses.
You reduced the time the ship was in the port of refuge.
Absolutely, that would have involved these allowable expenses.
And it's specifically covered by Rule 11, this situation.
Indeed, but again, my learned friend is relying on this because he is seeking to introduce into Rule F some requirement of specific intention some specific intention in relation to the incurring of the extra expenditure, and we say it's simply not there.
Yes.
Not in Rule F. I mean, this in our submission was a very simple case because the extra expense did have the effect of avoiding allowable expense, and an inquiry into what the owner's motive was in incurring the extra expense is really beside the point. Now, my Lord, I'm struggling with time, my Lords, but I will move as fast as I can.
Well, how are we doing? Because we need to have some idea of how we're getting on.
Yes, my Lord, I will certainly have finished what I have to say on both parts of my case by about in an hour's time.
Well, if we can try for 3:30.
I'm doing the best I can. Yes. So, my Lords, this authority, I recognise it for what it is, but we say it's very slender authority for an importation of some requirement of intention into Rule F. My Lord, paragraph 116 of my case, my friend actually bumps up his requirements of intention, and sorry, I was behind. Thank you very much. Where he introduces a requirement of having to appreciate a choice and a requirement that the choice must be with the intention of incurring less expense than the other course of action. So it now has to be an intention specifically to reduce expense. I've given you the case of the container line where expenses may be incurred in substitution for port of refuge expenses to get the containers to destination. There is no necessity, I suggest, to reduction of expense. Indeed, the forwarding of containers to their destination will usually involve greater expense than keeping them at the port of refuge, and they are, that greater expense is allowed only up to the limit. Now, my Lord, paragraphs 120 and following, my learned friend seeks to support a rather weakened version of the only one course of action available, no true alternatives argument. And he says his argument rests on the proposition that a negotiation, whether long or short, is one course of action, the result of which is outside the control of the ship owner. This, in my submission, my lords, falters on the same grounds as the stronger argument adopted by the Court of Appeal. It refers to and relies upon courses of action, whereas what we are concerned with is comparing and contrasting expenses, courses of expense. And it simply cannot be pretended that the expense of negotiating with the pirates will be the same expense, regardless of whether or not the relevant exchanges consist simply in what might be termed capitulation, followed by a short discussion of the modalities of ransom delivery and release, or whether they consist in a long period of negotiation to reduce the amount of the ransom, followed by the same functional exchanges. Looking at the whole course of a possible negotiation with pirates from the perspective of expense, there is not simply one course of expense available here. There are, we suggest, many possible courses of expense, each of which will result in different expense incurred and different expense avoided. And it is, we suggest, wholly artificial and simply a product of the true alternative course of action gloss, which my learned friend disowns, that allows you to treat this as all one and the same thing. The remarkable paragraphs that we referred to in Lord Justice Hamlin's judgment only hold water if one takes and accepts the reasoning that courses involving the same sort of behaviour are not true alternatives. And my lords, what one needs to keep an eye on here is that the expenses in issue are only the expenses of negotiating the ransom downwards, not all the costs of wages and consumptions incurred while the vessel was in the hands of the pirates. Mr. Agasbury, the original adjuster, took the view that these costs of the financial negotiation, and only the financial negotiation, replaced payment of the first demanded ransom. What is not an issue, and what Mr. Agasbury did not allow, are the post-agreement expenses incurred not while negotiating financially, but simply while sorting out the modalities of delivery of the ransom and release of the vessel after agreement on numbers had been reached. As my learned junior has put it, those expenses appear on both sides of the equation. What we're concerned with are the expenses incurred and avoided. And to the extent that my learned friend seeks to adopt the Court of Appeal's approach that any treating with pirates is the same as any other treating with pirates, that this, however you treat with the pirates, it's the same course of action. Well, is it the same course of expense? My lords, plainly not. A treating that involves capitulation and immediate payment involves very different expenses. My learned friend makes a point at paragraph 127 that the expenses claimed here do not share features with the expenses typically allowed in general average. Now, my lord, to the extent that that is true, it is altogether unsurprising substituted expenses allowed under Rule F are almost by definition not expenses that qualify in what might be termed ordinary general average. They are, if they did, you would claim them under those rules. Whether they bear any relationship to expenses that are ordinarily allowed under another rule will be a matter of chance, simply a matter of the kind of substitution that has taken place. So my Lord, reject that point. Then he says, my Lord, and this is also in paragraph 127, they're not incurred voluntarily or intentionally, but were incurred involuntarily while the pirates held the vessel. Now, my Lords, that is not an entirely new point. It's a point my learned friend made to the Court of Appeal in support of his no alternatives argument, but the court did not adopt it, and it was not a point made to the judge. So, if you like, it's a respondent's notice point. I would simply say at this stage that we dispute the whole proposition. The owners here did have a sufficient degree of control over the incurring of crew wages or continuing bunker consumptions, in that they could have decided to stop that course of expenditure by agreeing to pay the first demanded ransom. And neither of the courts below thought otherwise. And we say that the decision to pursue a course of negotiation rather than immediate capitulation was at least an effective cause of the continued incurring of these negotiation period expenses. It's wrong, therefore, to say, as my friend does, that it's all an integral part of the original event. That would only be so if, from the point of view of the hijacking, there were in law no recognisable alternatives to what took place. But as soon as that proposition has gone, as soon as Lord Justice Hamlin's rather strict gloss on Rule F has gone, and we are engaged in the question of whether, in fact, there were any alternatives to the continuation of these expenses, my lords, obviously there were. There was the option, paragraph 49 of the Court of Appeal judgment, there was the option presented to my clients at the outset, which was to pay and stop those expenses and move to the next stage, which would have been a discussion of the modalities of delivery. My learned friend then says that the bunkers were stolen by the pirates. My lord, that's not a point that had been taken before. It's not raised before the judge or the Court of Appeal, and it's not right. These bunkers were consumed in keeping the vessel electrically alive. Bear in mind, this is a pressurized gas carrier. It was to keep the cargo in safety while the vessel was detained. It was unavoidable bunker consumption if the amount of the ransom was to be negotiated. It's much too late in our submission to dispute the character of the bunker consumptions. The court below has found that the bunker consumptions were extra expenditure incurred by my clients, and that is explicitly found in paragraph 86 of the Court of Appeal's judgment. Then, my lord, it is suggested that these were ordinary expenses and therefore quite unlike the extraordinary expenses usually covered by Rule A and the like. But, my lord, the numbered rules also cover ordinary expenses, wages and maintenance of crew during a period of repair. For Rule F purposes, it is sufficient to notice that the expenditure we are claiming was extra expenditure, and the judge found that it was, incurred by the owners, and its character in other respects, whether it's ordinary or extraordinary or how it's to be characterized, is unimportant. And then it is said that these are expenses incurred during a period of delay to the vessel. Well, my lord, so too are many expenses allowable under the numbered rules, wages and maintenance of crew and so on. Why not expenses incurred under Rule F in place of the incurring of those expenses, or indeed other expenses? Now, my Lord, at paragraph 128 of his case, my learned friend says that he recognises that expenses may be deemed allowable under Rule F, even if they're not allowable under other provisions of the rules. Well, that is undoubtedly correct, but then he says it's not a licence to treat any expense at all as qualifying. My Lords, it's not quite clear what he means by that. Any expense that is incurred in place of another expense, which would otherwise be allowable, does qualify. It's difficult to find any other basis for restricting the operation of Rule F. And that's a reference to that rather curious passage about rigorous examination. My Lords, I can't pick up every single one of the answers to my learned friend's new points, but there is a new point at paragraph 147. This is page 172.
Yeah, I mean, you are going to have a reply, so you'll bear that in.
Well, I may have to make use of it.
Well, yes, that's right, it's there.
Yeah. The submission is made the suggestion is made that our submissions on the operation of Rule F assume that it is within the appellant's power to bring a negotiation to an end by accepting the amount demanded. But there is no evidence to that effect at all, and it does not grapple with the proposition that these are not contractual negotiations. I'll leave that second suggestion aside for the moment. But, my Lords, this is a new point. This is the point that was left out as not necessary in the grounds of appeal to the Court of Appeal. That it had not been demonstrated that there had been a saving of expense. And that was said to be not necessary there, but it's advanced again here. And rather unfairly, we say, it makes the point that there is no evidence, no finding of fact, no evidence to support what was never suggested to be a matter of any importance before the trial judge or indeed the Court of Appeal. Now, this factual lacuna point, as I say, was not before the judge. And we say it cannot be, and it wasn't raised on the pleadings, and it can't be allowed now. But there are a number of answers to it. We say, first of all, that to the extent any issue arose as to whether the incurring of the negotiating period expenses did replace payment of the higher ransom, the judge implicitly found that in allowing these expenses and all of them under Rule F, he allowed the full panoply of these expenses. And if there has to be shown some connection between that period and what would have happened if that course had not been taken, we say that it is an entirely legitimate factual assumption to make that had agreement been given to the first demanded ransom, the vessel would have been released within the same time period after agreement as was in fact the case, some 5 or 6 days. But, my lords, that doesn't even have to be shown either, even if that is a possible inference. What has to be shown...
It's a counterfactual. How could you possibly prove it one way or the other? I mean,
quite so.
This is a situation where one has to make certain robust assumptions.
Your Lordship can make some robust assumptions. May I assist you in doing so even further? What has to be shown is that the negotiation period expenses, that is to say, the costs of conducting the negotiation, were incurred in place of some other probable and allowable expense. Now, you don't have to satisfy yourself exactly what would have happened if the negotiation period expenses had not been incurred. What you do have to be satisfied of is that if the different course was taken, if instead the message had gone back to the pirates, yes, we agree you're 6 million, can we now work out when the vessel will be released and when we'll deliver the money? If that had been the message that had gone back, you don't have to make detailed findings of what would have happened then. What you do have to be satisfied of, and can be satisfied of in my submission, is that if that had happened, there would have been a payment of a ransom, and it would have been substantially higher than the 1.85 million that was in fact incurred, quite sufficient to cover the 160-odd thousand of negotiating period expenses that were incurred. I can put this in a number of ways, but the argument is this, that by choosing to negotiate, we avoided any expenditure under another course of action. And if that other course of action would have involved allowable expense of sufficient amount, then there has been a saving. The precise counterfactual, well, it's not necessary. My Lord, these and other points are made at paragraph 77(1) of our case, 105 to 106. There is a suggestion that payment of the first demanded ransom would have been artificial. The difficulty with that, my lords, is that the Court of Appeal has found otherwise, both at paragraph 49 and also at paragraph 81 of its judgment. I can just read you what was said in paragraph 81. The safest, most timely and effective means to secure the release of a ship and crew was to pay a ransom. It follows that the most safe, timely and effective means of so doing is to pay as soon as possible. Maybe that the general practice was to try and negotiate the ransom, but that does not mean it would be unreasonable to pay the ransom straight away. This is issue 2. So as to avert the real danger to vessel, cargo and crew as quickly and effectively as possible. Nor can a course of action which procures such real and tangible benefits be regarded as an artificial invention.
And this is all general reasoning, but there's a contrary argument, isn't there? If you cave into the first demand, it encourages somebody else to do it again, even more. And I would have thought that ship owners generally would be rather surprised with the message, and indeed any people involved with ransoms, that the best thing to do is to pay up immediately.
Your Lordship has moved me into issue 2.
Well, you seem to be on...
I really just wanted it for the last sentence, not an artificial option. In fact, it's the option that was given.
Not an artificial invention.
Yeah. May I come back to that question? The question really is, as to whether it's reasonable or not, focuses on the Hudson conundrum, and the question that arises is whether it is sufficiently reasonable to allow the admission of the substituted expenditure. My Lord, I want to say very quickly something about real choice. There are suggestions in the Court of Appeal's judgment that there has to be some actual cogitation on the part of the ship owner.
Yeah, we've been there.
I said...
I've had this already.
We have really, yes.
Yes.
I may not need to say any more. But in our case, we have also set out the evidence which we say shows that there was a real cogitation on the part of my clients as to whether or not to pay the first demanded sum. There is a couple of paragraphs in the statement of Mr. Reapen, who was one of the commercial managers, where he says they waited until the first demand was made, and they considered it, and they decided to negotiate for a preferential figure. So we say that is perfectly sufficient evidence of actual cogitation. We have certain complaints about the way in which the Court of Appeal adopted evidence inappropriately to prove the contrary, or to try to establish that there was no consideration. They had overlooked what Mr. Reapen had to say, and they reached the conclusion that there was no cogitation. We say that was inappropriate and wrong. Firstly, Mr. Reapen concludes the matter in his statement, and, well, I'm taking this far too quickly, but...
I don't think you are. Yeah.
Some reliance was placed on a statement in the opinion of the advisory committee that in their experience there was always a negotiation of the ransom. Now, my lords, we can make a large number of points, many of which are made in our case, about that use of the opinion or statement of experience of the advisory committee. We say it's inappropriate because there was no expert evidence in this case admitted, and it shouldn't have been just picked up as a statement of expert experience or opinion. But, my lord, the fundamental point is this. Just because the average adjuster sees something always being done, it doesn't mean that no choice was made. Just because ship owners almost always negotiate, it doesn't mean that the ship owner didn't have a choice of whether to negotiate or not. And the average adjusters just see the result of that cogitation, not their experience doesn't show whether any such cogitation takes place.
Really linked, this is where the two issues link, isn't it? I mean, if it was reasonable to cave in straight away and pay up, then obviously there was a choice, one would have thought, on the face of it, despite what the Court of Appeal said, that there was a choice not to do that, take that reasonable course, but to take another reasonable course.
My lord, yes.
If on the other hand, it's absolutely blindingly obvious that you're not going to pay the initial sum, especially if it's likely to be more than the value of the ship and cargo, then the position may look slightly different.
Well, now...
There isn't a real choice. To use the Court of Appeal's language, it's obvious what you do.
It's time I got to issue 2, isn't it? I think, my lord. I think
this is why they link.
They are linked, and we say actually the tension between them is very, very indicative of the existence of a real choice, that there is a choice to be made. Once you accept, as the Court of Appeal did and the trial judge did, that the option of paying the first ransom is a reasonable one, it's very hard to imagine that there is no choice in the matter, no actual cogitation of the option. So if real choice is part of the requirement of Rule F, then the likelihood is that there was real choice. Well, Mr. Reapen's...
The reality is, if the ship owners had paid the 6 million,
yes.
They would have been taking an incredible risk. Cargo would have said straight away, why on earth should we contribute on that basis? That's grossly, that's a ridiculous thing to do. Nobody has ever done it before, no one's ever going to do it again.
My lord, your lordship is launching, if I may say so, 4 square into the Hudson conundrum. Yeah. Yes, this is the difficulty with the paradox.
I fully accept.
Yes.
If you take it at face value.
Yes. Now, let's be clear. My lord, I'm going to move to, because of time, I'm going to move to issue 2. I have not addressed what my learned friend has to say on Rule C of the York-Antwerp rules, which, although he trails some submissions in his case, he doesn't revert to them at any time when addressing issues 1 and 2. And in my submission, it's simply not open to him to make argument on Rule C, because he eschewed taking that course in the Court of Appeal. There was a potential ground of appeal that on Rule C that was withdrawn. We've had no notice of it, and it's
But we'll see what he says about it.
quite a substantial argument. So
We'll
I'm
see
going
what
to
he-
skip it and see what he has to say about it.
Okay,
Now I'm going to move to issue 2, and my lords,
yes?
as you know, both the judge and the Court of Appeal were with us on issue 2.
Issue 2 doesn't include the Hudson conundrum.
It does
It does.
involve the Hudson.
I mean, basically, the problem for you on the Hudson conundrum, it is said that as a matter of language,
Yes,
F refers back to A, and A has to be reasonable.
yes. And what both the Court of Appeal and the judge said or concluded, they
Yeah.
both took the same view, that in order to make sense of Rule F, in the context of allowability with a reasonableness
yes.
requirement, the requirement of reasonableness in the context of Rule F had to be given sufficient latitude to make sense of Rule F. In other words, and there's no dispute
What does
about
that mean? You're more generous in saying
Yes.
reasonable when you...
Yes,
So it has a different meaning when Rule A is related to Rule F and what it means when you're looking at Rule A on its own.
my lord, that appears to be the logic of what both the Court of Appeal and
And do you adopt that?
my lord, if necessary, yes. Well, I've won the point twice. I'm not going to drop it now.
I didn't suggest you did. I just wanted to make sure you...
We have, however, it's fair to say, we have throughout this litigation run an alternative analysis,
Namely,
which is dealt with in our case, and I had hoped your lordships might have
Yep.
seen it. At the end of our case, the alternative analysis finds some inspiration in the dissenting judgment of Lord Justice Hoffman in the
Yes.
Vigella.
Yes.
And he took the view that in order to make sense of a different Hudson conundrum, in that case it arose in relation to substituted expenditure
Yep.
under Rule 14, and the problem arose, how could there be in that case an avoided course of necessary
Yes.
expenditure? It's a slightly different conundrum, but the same issue arises with the avoidance of reasonable expenditure.
so what you basically drop the reasonableness.
What we say, and what Lord Justice Hoffman said, is that the reasonableness of the course of conduct avoided has to be analysed on the premise that the substituted course was not an available course, could not be done.
But if you go back to Rule A,
Yeah?
when Rule F is engaged, the expenditure you're looking at is not merely never reasonably made, it's never intentionally made, is it? Because by definition, it's not made.
No.
So do the words intentionally and reasonably made simply drop out? Because intentionally must, because you can't not make a payment.
Well, you can't intentionally make
intentionally.
a payment you don't,
Don't make, yes.
Yes.
And therefore doesn't reasonably, isn't it fair to say it reasonably drops out with it?
Well, my lord, that is certainly one solution. It's not one that has been adopted by either of the courts.
Well, I'm asking
Below.
you what you think about it. Sometimes ideas from the court are not very good on analysis, but I'm just putting it to you.
No, what we do suggest is either that we adopt the position taken by both the judge and the Court of Appeal below, which is to give a very extended latitude to what is meant by reasonable,
Including unreasonable.
not as far as unreasonable, but
Well,
reasonable in the broadest context. So
payment that would be unreasonable under A becomes reasonable when A is read with F.
perhaps one has to look at it in terms of Rule F, which is the question one is asking under Rule F is it proper to allow the substituted expenditure in replacement of this allowable expense?
So intentionally and reasonably magically jumps into F out of A.
Well, what I'm suggesting is that the word allowability in F, which is the word in F, allowable expense, that one has to try and resolve the paradox by either giving the touchstone of allowability in the other rule, if it's reasonableness, a broad width. But if it's necessity, what if the touchstone is necessity in the other rule? What if one is under Rule F, one is incurring substituted expenses to avoid what would otherwise be allowable only as necessary expenditure? It creates enormous difficulties, this conundrum. And in our submission, there are two ways of dealing with it. Either, as the Court of Appeal and the judge did, to say, well, you must just give reasonableness a broad understanding. In the context of Rule F, is this the sort of avoided expense that would justify the allowance of this substituted expense? Or alternatively, the approach that was taken by Lord Justice Hoffman in the Bigella, which is to say that for the purpose of working out whether the avoided expense was a necessary expense or a reasonable expense, you simply ignore the fact that there was a substituted course available. Yeah, it's got to be, if you like, necessary on its own terms or reasonable on its own terms, ignoring, for those purposes, the availability of the substitute.
Was Lord Justice Hoffman the only person who addressed that question?
Yes, my lord. The other two members of the Court of Appeal in that case said that the conundrum could not be solved, and therefore, in effect, that the whole rule on temporary repairs was unworkable. Effectively, the majority said that Rule 14 just didn't work, full stop. Lord Justice Hoffman was prepared to make an implication into Rule 14 in that case, we would say into Rule F in this case, that in judging whether or not the avoided expense would be allowable, one ignores the fact of the availability of a substituted course. One looks at it on its own terms. And, my lords, we've set this out in our case.
What did they say in the House of Lords about that?
My lords, in the House of Lords, they found a completely different solution that had somehow eluded everyone below, and they were prepared to transfer an assumption in Rule 14 that the temporary repairs had not in fact been carried out. They said that could be transferred across to, I think it was Rule 10 in that case, and that was to be read into Rule 10, and therefore you could treat that as the basis upon which the necessity of incurring the avoided expenses was to be judged. Gosh, that's a difficult way of putting the point. My lord, we put this very clearly, if concisely, in our case. The essential reasoning of Lord Justice Hoffman is it's paragraph 105 of our case, page 122 in the electronic bundle. So, my Lord,
But you
that
still
is-
have, I mean, that sort of parallel reasoning of the majority wouldn't help you, would it? Because if you carry across from Rule F,
Your Lordship is now in the House of Lords.
yes,
Yes.
if you carry across from Rule F into Rule A, an assumption that the extra expense incurred allegedly in place of the other expense had not been incurred, you still end up with the basic question under Rule A, whether the avoided expense would have been intentionally and reasonably made and incurred. So you'd be in trouble on that if the Court of Appeal and judge fail.
In the House of Lords, they found in Rule 14 an express assumption that could be carried across to Rule 10.
Which isn't here.
There isn't one here.
So you have to look at the...
So that's why I'm interested in what Lord Justice Hoffman said in the Court of Appeal, because in the Court of Appeal, that solution that appealed to the House of Lords did not appear possible, did not appear available. And he said, in those circumstances, in order to rescue Rule 14 from incoherence, paradox,
he arrives at the same result as the House of Lords
Yes.
by a different process of reasoning.
Right.
Failing to pick up the phrase they picked up, he just implies it in some way.
and it's his process of reasoning that I appeal to as this alternative analysis.
Yep.
Because it's necessary implication in order to save the rules from incoherence or paradox. But, my lords, let me emphasise that the alternative analysis of a broad latitude to be given to the concept of reasonableness in the context of Rule F is common ground between my friend and I. He agrees with
He agrees with a generous view. But, I mean, the trouble with your drawing, analogizing from Lord Justice Hoffman is that it flatly contradicts the wording of Rule F, which is that the expense has got to be incurred in place of another expense which would have been allowable. You can't then postulate that that other expense wasn't available. The whole of Rule F postulates that it was available and would have been allowable.
I understand that point, I do indeed. What I'm suggesting is that when one comes to assess whether it would have been allowable,
It's available. So 1 minute it's available, the next it's not.
Yes, I'm afraid that has to be the submission, that it has to be an expense incurred in place of another allowable expense. But in working out what is meant by allowable, would it have been allowable? We say the answer to that question has to be addressed on the premise that the substituted was not an available option. Yeah. So, would paying 6 million have been a reasonable thing to do if the substituted expense, that is to say, negotiating, was not an available option? Answer, yes. Now, I understand, of course, there is difficulty with this, and so also, let's be clear, the judge found difficulty with it, although he found considerable attraction also to this solution of the difficulty created by the Hudson conundrum. But ultimately, he went for what is now common ground between my friend and I, and has been the solution adopted both in the Court of Appeal and by the trial judge, that in assessing what is whether an avoided course is allowable, there has to be latitude when the touchstone is reasonableness. And we say, what is that latitude? It is the latitude that will make sense of Rule F. Because if you allow the availability of the avoided course, the availability of the substituted course to influence whether or not the avoided course would have been reasonable, in very many cases, unless you give latitude, it won't.
Is that right?
It's self-defeating.
If Rule F is looking at situations where normally there is an available means of continuing the venture in the original way contemplated,
Yes.
then that is the benchmark. And all that Rule F is allowing for is that there may be ways in which ship owners, or cargo probably, can step outside the ordinary contractual means of performance of the venture, do things with which they wouldn't otherwise be allowed to do, and nonetheless recover the costs of those in general average. That seems to be the thinking in relation.
That's one, and if your lordship studies the judgment of Lord Justice Hoffman in the Bigella, you will see how that has been allowed to work. One of the ways in which it's been allowed to work is to treat avoided, in cases of towage and transshipment, the rubric of the equivalent here of Rule A, the rubric of the avoided expense rule, has referred to the avoidance, the incurring of general average costs necessary for the continuation of the voyage. I'm slightly paraphrasing, but the question that would arise is, how can those expenses necessary for the continuation of the voyage have been avoided? How can they both be necessary and avoided? Now, the way in which the rules have got past that is by taking a rule of English law and saying that, towage to destination and transshipment is not completion of the voyage. It is, in fact, the exercise of an option by the ship owner to complete his contract in another way.
Yes, well, that's really the sort of point I was putting to.
Yeah, well, that is how it works in those two cases, in those two rules. But it doesn't work everywhere. You still, in other areas, have problems of claiming for substitute expenses on the basis that they have avoided necessary expenditure.
Can you give us some examples? That are common ground, that are controversial.
No, my lord, what I can do is to show you rules where the touchstone is necessity. Let me give an example off the top of my head. A ship breaks down shortly out of port. If she were to return to port, I'm sorry, my lord, I'm just going to pull up my copy of the rules. Yes, my lord. This is Rule 10. When a ship shall have entered a port or place of refuge, or shall have returned to her port or place of loading in consequence of accident, sacrifice, or other extraordinary circumstance which render that necessary for the common safety, the expense of entering such port or place shall be admitted as general average. Now, my lords, if instead of taking that course necessary for the common safety, because the ship is immobilized, the vessel is taken in tow and taken to destination, one asks oneself, what allowable expense has been avoided by this towing to destination? And you would have to say, we've avoided the cost of going into a port of refuge, which would have been necessary for the common safety.
That's another example in the same
But, my lord, it
category.
wasn't necessary for the common safety because the vessel safely reached her destination under tow.
No, but that's another example in the same category where
Yes.
if you're going to fulfill the voyage in the contractual way, then you would require to repair. But you are allowed to step outside that mode and be towed, which is a most unusual way for a cargo vessel to proceed.
Your Lordship says that. I venture to suggest it might be a little unique to English law to regard towage to destination as not completion of the voyage. Now, I know it is English law and I accept it, but and we have to bear in mind this is the York-Antwerp rules and it applies internationally. And I do wonder to what extent all nations applying the York-Antwerp rules would say that, oh no, of course they've towed the vessel to its destination, that wasn't completing the voyage. It always is, in my submission, it's a rather peculiar rule of English law. I can well understand transshipment, but towage to destination? Well. Anyway, my Lord, what I'm pointing to here, forgive me, I'm now seriously over going my...
You've been asked quite a few questions.
I have, my Lord, and there is...
But, yeah, you better... No.
There is difficulty in dealing with Rule F. Now here the rubric, my Lord, what I was showing you here,
Yep.
Rule 10, I was showing you Rule 10 on page 446. Now here the rubric of allowance or allowability is necessity for the common safety. It's not necessary for the completion of the voyage, so you don't have a get-out there. If one is looking at the first paragraph of Rule 10, if it would be necessary for the common safety for the vessel to return to port, but instead the vessel is towed to destination. How do you get in the avoided costs of returning to a port of refuge? Avoided by taking a substituted course. There is a real difficulty with allowable expense in Rule F if you take the touchstones of allowability in the other rules, either literally or without some relevant assumption.
I think we have...
You've got that point.
Yeah.
Yes.
Yeah.
Now, my lords, a lot has been said in our case on rule, on issue 2.
Yes.
And I just wanted to very quickly remind you of that. Both the Court of Appeal and the trial judge adopted the same approach.
Well, we have that point, yep.
And they have, in a way, arrived at concurrent evaluations of the case by reference to the same standard.
Yep.
And we say you should therefore, your lordships should not therefore disturb what are concurrent evaluations of the facts by reference to a clear legal standard.
Yes, I understand that.
And we've given you the cases on the disturbing evaluations.
Yeah, well it's very familiar territory. Yep.
The only other matter I need to address is my Lord Mance's point on running expenses.
Yes.
And I just wanted to ask my Lord Mance whether he'd kindly reiterate the point so I can deal with it properly. My Lord, your Lordship had a concern about running expenses or ordinary expenses, about whether they should be allowed under Rule F.
I think we've covered the topic quite a considerable extent, and I certainly can't remember the precise question I put to you.
Well, I notice we've got a transcript, so if we see that, Lord Mance no doubt can look at it, and if something occurs to him, he'll put it to you.
Very good.
Perhaps you'd like to send an email to the court identifying the particular question which you think you didn't answer.
My learned junior has a job for the evening.
I take it we'll be getting a copy of the transcript if one's been made.
I hope I'm getting a copy.
That's not what I asked you. I thought we are getting a copy.
Yes. My Lords, I had a great deal more to say, but I'll keep what I need to say for reply.
Thank you. Thank you very much. Mr. Saul.
No, I have nothing to need.
Very much. Mr. Crowe.
I was a little too hasty, I do apologise. My Lords, the issues on this appeal arise out of the performance of the contract of carriage between Norway and Vietnam. That contract was part of a bundle of contracts which are of some relevance in this case, because in the end, the application of the rules, as I'll call them, arise as a matter of contract. They don't arise as a matter of law, they arise because they form part of the parties' contracts. Now, the details, insofar as we have those, of those contracts, are set out in the adjustment, and I'm not going to take you to them now. But let me just remind you of them. The ship owners time-chartered the vessel to a company called Bridge Chartering Marine of Monrovia, and they time-chartered it on the Shell Time form terms. And interestingly, and I'll return to this, they appear to have time-chartered on a basis that hire remained payable during the period of the piratical seizure. So the ship owners received their hire throughout. And I can show you that because that's made crystal clear in the adjustment. In turn, the time charterers voyage chartered the vessel to another company in the Mitsui group, Benelux company, and they did so on terms, as you all might expect, which provided for freight to be paid. And freight was effectively the essential reward that was being provided for the carriage of the goods, as one always sees. And there was, in addition, a bill of lading as between the ship owners and cargo. That's how we find, that's one of the ways in which we find the rules incorporated. But I'm not going to turn any of those up because you have the references in the written cases. Now, what's important as a starting point, we say, is to give consideration to the terms on which freight were agreed. When freight was agreed, doubtless one can say this objectively, you would have expected the parties, certainly the time charterers, to have regard to what might regard to be the ordinary contingencies of a voyage. They would have understood that that freight would earn them, wouldn't change if for any reason the voyage perhaps lasted a little bit longer than it might do if all went well. Weather conditions were bad, they wouldn't get any more freight, but their operating costs, that is to say the bunkers they had to burn, and the hire they had to pay, would increase. The same would be true for any other form of prolongation of the voyage. For example, if the vessel grounded during the course of the voyage, they couldn't expect to receive any more freight, and so long as owners were not themselves responsible, they couldn't expect a contribution from anybody else for their costs during any period of prolongation. The same would be true if there was, for example, a mechanical breakdown, which meant that the voyage was lasted much longer than would otherwise have been the case, and perhaps longer than they had hoped when they agreed a freight rate. Now, in those events, the examples I've given you, grounding, mechanical failure, the freight would remain the same, the operating costs would go up. Who bears that risk? In this case, the time charterers. They have to bear that risk. That's the nature of the arrangement. One way to consider the issues on this appeal is to look at it this way and say, is there a special rule in the context of piratical seizure which creates an exception to those general principles? Meaning that, unlike the case of the grounding or the mechanical failure, time charterers do get a contribution towards their additional running costs. They do get something back from others involved in the adventure, where ordinarily they would not. But it isn't even put as broadly as that. It arises in a very specific way. It is not said it arises simply by reason of a piratical seizure. It arises not simply because that's the starting point. There then needs to be a negotiation about trying to obtain release through ransom. There needs to be a negotiation about the amount of the ransom, because that's the critical feature of this case. It's negotiation about the ransom. That needs to be then said to have somehow increased or prolonged the voyage more than simply the seizure itself, or the negotiation but it would take its course anyway. So in that little window caused by a negotiation about the size of the ransom is an exception to be created. an exception that we don't find in the place where we normally find exceptions in relation to the law of general average, that is, say, the numbered rules. As we know from the structure of the York-Antwerp rules, we have the general rules, they're lettered, they give us the principles, and they're general in their type and in their application. And then we have the numbered rules, which address specific circumstances. And we don't find a numbered rule that corresponds to this event. But what my learned friend has therefore to do is to find a place in the general rules, rule F, to create this exception. If he does so, might he also be creating an exception that has application elsewhere? What is the difference, my lords, between a negotiation with pirates about the amount of ransom and the negotiation, for example, with a salvor about the cost of refloating a vessel? I know many salvage contracts will be on standard forms, but that won't be true of every case. Or, for example, the negotiation with a repairer as the cost of repair. Now, in those circumstances, it's never previously been thought that the other parties, the maritime adventure, must contribute towards the ship owners, or in this case, the time charterers' running costs. But there's no difference in principle between that case and this. It's maybe a more striking case, but fundamentally the principle is said to be the same. And my learned friend is keen, very keen, to invite you to take a broad approach to Rule F. I'll come back to what's left of Rule F if he's right on his construction. I shall say not a great deal. But if he's right, and if you accede to his submissions, there will be implications beyond the particular facts of piracy. So we do say, and it picks up a little bit on my Lord Mance's point about risk allocation. The risk allocation in these circumstances is actually tolerably clear, and the parties know what it is. This appeal about is saying, shall we change it? Shall we alter it to take account of this particular circumstance? Or putting a different way, do these circumstances justify the alteration because, and I recognize this is the logic, the parties have in fact agreed to it because that's the effect of incorporating the rules. Now, just by way of introduction, an important introduction is Rule F, because Rule F is the only gateway available to my learned friend.
Understood.
And therefore, you've already seen Rule F at some length.
Yep.
So I'll take this as quickly as I can. But my learned friend must therefore demonstrate that this is a case of an extra expense being incurred in place of another, which would have been allowable in general average. But what does that mean on the facts of this case? He's saying that the running costs of the vessel, increased as they are by the period by which it is assumed it's prolonged by reason of the negotiation of the ransom amount, first of all, it's an expense. Secondly, it's an extra expense. Thirdly, it's one he has incurred. And he says it's been incurred in place of another that would have been allowable in general average. So all of those elements need to be, now, in a sense, all of those, it's tempting forensically to break it down into little elements. So in reality, it's probably a rule that's meant to work as one thing. You're either inside this rule or you're not, and there's various ways in which you might not be inside it, including, for example, if you haven't made any saving in general.
It's a single rule with several components.
It is.
Yeah.
It is, but I think it's important when looking at the components, my lord, to be aware of what surrounds it and to read it as one, rather than to take each component and then by adding it together maybe get something other than what the rule intended.
Well, that's probably true of any rule with more than one component, but anyway, I see. Yep.
So, now on the, we say that, just dealing with relation to issue 1 for the moment, there are a number of difficulties with my learned friend's position in relation to issue 1. First is this: the enhanced voyage costs were not in fact incurred by owners at all. They're incurred by time charterers. Let me just show you that, because I've made that proposition once. Perhaps I just need to show you, make that good. It's in the core bundle, page 256.
Yes,
This is part of the adjustment.
yes. Rule 11, yep.
It's internal page 11, paragraph 9,
Yep.
256, those working with tab numbers, tab 8,
Yep.
sub-tab 5. This forms part of the adjuster's notes. This is, I'm not going to take you to it now, but this document is where you find much of the core information. But at 9, you find what's clear.
Yes.
Notwithstanding the hijacking period, the vessel remained on hire in accordance with the clause of the time charter party. So the payments of time charterers for the time charter hire and the bunkers consumed did not cease. Therefore, the allowances made good in general average, crew wages, bonus, crew maintenance, and consumption of bunkers, that's exactly the allowances we are concerned with, my lord. During the on-hire period, when the ransom amount was negotiated, shall be for the benefit of the time charterers, which have been taken into account in the final settlement of the adjusters. So that's just demonstrating that in this case, but this case is in no sense unusual. This case is, if you like, your archetypal Somalian piracy situation. It follows no unusual pattern. But in this case, as it will with many, the party who will be bearing the operating costs may well be a very different party to the party who is negotiating the ransom or interested in the value of the vessel, for example. The time charterer's interest is a very different one to the ship owner's interest. That doesn't stop general average being applicable. I don't say that for a minute, but it may be relevant when one comes to ask oneself the question, did anybody have a real choice? And if includes with it any sense of intentionality, well then, did ship owners, in a sense, choose to incur this expense rather than that, when in fact they aren't really incurring the actual expense they say is the additional expense, is the extra expense. They're making time charters do that. Ship owners aren't saying, we're making for ourselves here, we're going to reduce the ransom payments, but in return for that, we're going to sacrifice the costs, the operating costs, because they're not. They're allowing time charterers to bear that loss. So that's my first observation. And that follows into my second observation, in that they did not choose to incur these costs. These costs, we say, were caused by two things.
Who's they?
Sorry, the owners, the ship owners. I'm sorry, my lord. If one asks oneself the question, why were these additional operating costs, voyage costs incurred? Two reasons. The original reason, of course, is there was an agreement to carry the cargo from Norway to Vietnam. That's how we happened to be on this voyage. That's how we happened to be going through the Gulf of Aden at the time we were. That's, if you like, an obvious starting point. And the second is, of course, because the vessel was seized by pirates.
Yes.
Is the logic of these observations that there are no circumstances in which the ordinary costs of running the ship, paying the crew and so on, can be allowable in general average, even if it is increased as a result of extraordinary events? Is that the submission that's being made?
Subject to where the general average rules themselves provide for it, which we see in Rule 11,
Right.
expressly doing so.
The analysis that you've given us assumes, as it happens to be the fact in this case, that whalers were receiving time charter hire in any event. But that raises the whole question of the relationship between contractual rights and general average. It might equally have been the case that they had time chartered our ship for a fixed freight. So, I mean, your submission only carries the emotional force that it does on a particular hypothesis which isn't going to apply in all cases.
So I don't suggest that the first point I make is decisive of anything.
We're not concerned with something analogous to damages here.
No, we aren't, though I would make the point, my lord, that we are, even when looking at the York Antitrust rules, concerned with contractual rights.
Yes.
Because they're in as a matter of contract.
We're concerned with the contractual right to have certain categories of loss adjusted according to the rules.
Indeed.
And that, on the face of it, operates independently of such other contractual rights as may arise.
Well, on the face of it, subject to the proposition that I shall make, which is that the rules are intended to operate so as not to cut across existing contractual rights, and you'll see quite a lot of support for that in the texts. The proposition, for example, and we see that referred to, that on the whole, if a party has agreed to be rewarded in a particular way for fulfilling their contract, the rules aren't intended to change the nature of that bargain in any way. So if you've taken that risk, the rules aren't there, if you like, to save you when that risk comes home to roost.
So the expense has to be, in some sense, a loss. Is that the submission?
Well,
because I can see that you might be saying, well, if under the same contract you are receiving time charter hire, the expense of paying the crew doesn't represent a loss. Now, are you arguing that it's a requirement that in some way it should? Or is this simply an anomaly that will arise if you allow crew costs, for example, to be charged to general average in any case, in any circumstances, whatever?
Well, certainly would say it is an anomaly. The question that arises then is it such an anomaly that you then have to say, well, when would it ever be possible? Which I think is your question, my lord.
Submission to identifying this as an anomaly, or are you running a broader suggestion that expenses have to represent an out-of-pocket loss having regard to the generality of the contractual rights of the owner?
Well, I'm not saying, I don't put it, I think, quite as high as saying it has to be a loss.
But I'm just trying to discover how far you go and in which particular direction.
Well,
or is this simply a commercial anomaly associated with any principle which would allow crew costs to be charged to general average?
Well, it's certainly a commercial anomaly, but I do say that as a matter of principle, unless the York Antitrust rules expressly provide in the numbered rules, effectively there's been an agreement by the parties to it, that a particular circumstance allows for recovery of this kind, well then it will be a very rare case indeed, where things which are, if you like, part of the contractual consideration will in any way be changed by those rules. So that's why I say I can see that if you're bringing in the numbered rules, there is an express exception that allows operating costs effectively, in some circumstances, Rule 11, to be borne by everybody in rateable share. But not so elsewhere, and only in very specific circumstances. And I rely in part on the fact that you have got quite defined circumstances, and I say, well, this isn't within that. Interestingly enough, perhaps not that interestingly, I don't know, the Average Justice Association considered, when it first considered this, whether you could put it in, whether you could regard the pirates' lair as a port of refuge, and they dismissed that as, perhaps not very surprisingly, they said no, and that's not something that's been renewed. But that would be the basis on which one might find it there. So I do say, I'm not sure I accept, I'm quite going as far as to say it must be a loss in the term I think my Lord Woodsumption suggests, but I do say you won't...
I'm not suggesting it for my part, I'm simply...
No, I understand that.
I'm sure that I understand whether you're suggesting it.
And I wasn't for a second suggesting that you were suggesting, I was simply trying to address your submission. That's my mistake again, my question.
On that happy, non-misunderstanding basis, is that a convenient moment, or is there any last half-in shot you want?
No, that is a
Can I
convenient.
just ask you one last question?
Yes, of course.
Would your argument be any different if there were no time charter at all? Where the ship owners on the one hand and the...
No, it would only be different. Let me be clear about this. The existence of the time charter doesn't make a critical difference. It makes a small difference if I'm right on other areas of construction, But if I'm not right on those, it makes no
Sort
difference
of
at all.
general merits point.
No, it's not. If choice matters, it becomes relevant, because then you have to say, who's made the choice on behalf of whom? But it doesn't arise otherwise.
10:30 tomorrow? Good. Thank you very much. I think we're obviously going to tomorrow afternoon, which gives you an extra half day, but we will not sit beyond 4 o'clock. And it would be unfair, I think, on you to expect you to finish necessarily much for 3:30, but that's not encouraging you to do so.
Yeah, well, I don't expect that I will finish. I will need all of that time, but it may depend on the questions. But I'm here to answer them, so that's all.
Well, if we finish earlier, that would be good. And obviously, we hope to and should, but you do have tomorrow afternoon until 4 o'clock if you need it.
Grateful.
Good. Thank you very much. Court's now adjourned. 10:30 tomorrow.